McCauley, are you going to be arguing, or Mr. Butler?
Yes, Your Honor.
I have read the papers, and clearly papers from last time, so if there's anything you'd like to add.
I'll keep it very brief then, Your Honor. It's our position, Your Honor, as you know, we had filed a motion pre-trial, and that was for a different purpose. Your Honor ruled on that, and we've respected that ruling. The defendant opened in this case and indicated, I counted 32 times, about the nature of the relationship between Odin Lloyd and the defendant. He constantly referred to him as being friends and suggested, because of that relationship, he had no reason, the defendant had no motivation or reason to kill Odin Lloyd. Part of what our motion is attempting to respond to is the suggestion that by using offensively the court's earlier ruling to then allow them to go to essentially beat the drum of this friendship, this alleged friendship, and then having the Commonwealth's hands tied to respond, specifically as it would be rebuttal evidence and relate to a motive to do exactly the act, when in fact the defendant has previously had a similar relationship under similar circumstances, in terms of even some small disagreement with somebody who was described as a very good friend of the defendant's, and then that he would respond in that way, and again with under circumstances that would suggest he did it in a way where other people were involved. There were two other people in a car. There was a shooting in a car. It was that Mr. Bradley was then pushed out of the car in an industrial park. In fairness, we think we should be permitted now that they have opened the door, not just in the opening, 32 times in the opening, then in the course of the questioning of witnesses suggesting that they were friendly, would hang out, do things together, that we just think it's fair, as a matter of fundamental fairness, that we would be able to put in that evidence to rebut the suggestion that essentially he does have no motive, when in fact such evidence does exist.
Thank you.
Thank you.
Your Honor, I want to address the merits briefly, but before I do, I have a particular concern about this filing and a related concern. Your Honor, the prior filings respecting Mr. Bradley have been properly made under seal because the content, the allegations that Mr. Bradley is making against Mr. Hernandez are based on his grand jury testimony. And it's my understanding that it's practice and in fact the requirement of this court that filings
it's not the court. There's a statute.
Yes, Your Honor. The prior filings about Mr. Bradley, it's my recollection, there have been a number of them, have been made under seal. The Commonwealth, Your Honor, chose to file this one on the public record on March 2nd of this week. And not surprisingly, it's been widely and quite breathlessly reported in the media. And Your Honor, this adds to growing concerns that we have about efforts to influence the media and indirectly the jury in this case. We've observed during the course of the trial, Your Honor, prosecutors often speaking with members of the media. Earlier this week, Your Honor, I read online the subject matter of the next day's witnesses before I received a list of those witnesses from the Commonwealth. Now, Your Honor, out of respect for this process and out of respect for this court's order on this subject, we don't speak with the media, Your Honor. We don't speak with them on the record. We don't speak with them off the record. We don't want to influence them. We just don't go there. Now, I understand, Your Honor, that the court quite properly inquires of the jurors every morning about whether or not they've been exposed to anything, and quite properly instructs them at the end of every trial day not to be. But, Your Honor, we all live in the real world. Information is ubiquitous, and it is frankly, Your Honor, hard to believe that nothing will filter through to the jury, and when something like this is put out there publicly, when it should be under seal, it adds to those growing concerns. So I simply want to state those concerns to the court. With respect to the merits, Your Honor, in the motion filed on March 2nd, the Commonwealth now says that this alleged shooting of Bradley should now be deemed admissible because the defendant referred to Odin Lloyd as his friend during opening statement on January 29th. The Commonwealth relies principally on two cases, Oliveira and McGraw. The Commonwealth's argument, Your Honor, is utterly frivolous. Essentially, the Commonwealth is arguing that Mr. Hernandez has a propensity to shoot his friends. That's their argument. And since they claim, or Mr. Bradley claims, unproven, uncharged, that Mr. Hernandez shot Bradley, who was allegedly a friend, therefore the Commonwealth should be able to suggest that Mr. Hernandez has a propensity for shooting friends, and since we say Lloyd was his friend, therefore they should be able to show that Bradley, another friend, was shot by Hernandez. Your Honor, it is frivolous. Your Honor, they can rebut, as they have tried to rebut, our contention that Mr. Lloyd and Mr. Hernandez were friends. They've sought to do so through the testimony of Ms. Ward, through the testimony of Ms. Tebow, and they've continued. That is a fair subject at this trial. This trial is about the alleged murder of Odin Lloyd by Aaron Hernandez. That's what it's about. That's what the court should focus on. There is no reason for the court to revisit, let alone change its ruling. All the parties have relied on the court's pretrial rulings. There has been no offensive use of any ruling by this court. Our contention that Mr. Lloyd... Yes, Your Honor.
I couldn't tell from one sentence in the opposition memorandum whether you were suggesting that had the defendant opened the door, the court would not be free to revisit the issue because it had not explicitly made it.
No, Your Honor, that's not what I was distinguishing that case. Of
I
course,
understand,
Your Honor,
but it wasn't clear to me whether you were
No, Your Honor,
further.
of course the court is always free, based on developments at trial, to revisit rulings. That's the court's prerogative. We are quite aware of rulings the court's made and our obligation not to open certain doors. If we were getting up here arguing that Mr. Hernandez, has never been near a gun in his life, perhaps that would open the door to other firearms evidence. If we were arguing if we were trying to present a character defense, perhaps that would open the door in the court's discretion to other evidence that would tend to attack his character. That's not our defense. The fact that we say he has no motive, the fact that we say he and Lloyd are friends, which I think we have and will continue to prove during the course of the trial, that's part of our defense. That's a completely appropriate defense. It relates to Odin Lloyd. It doesn't relate to anybody else or his relationship with anybody else. And no doors have been opened. Nothing has changed. They haven't said a peep about this since January 29th. We are now well into the second month of this trial, if not the third month, depending on how you count it. And there simply is no basis for the Commonwealth's argument. And moreover, Your Honor, the case law they rely upon, as I'm sure the court has seen, is utterly inapposite and should not have been even cited in support of this motion. Thank you, Your Honor.
Your Honor, could I speak to the two points he brought up, the sealing? All this information, Your Honor knows, we argued this in open court. So there was nothing referencing grand jury, and there was no intent to do what Mr. Sultan is suggesting. That has been out in the open for a long period of time. It just raised the issue of what the evidence would be to rebut the 32 times. That's not an accident that was then proffered in the opening and then followed up in the course of this trial. The other suggestion is the first time I'm hearing that about somehow witnesses by the courts, with the courts at the court's direction, providing witnesses for the following day. Some of those decisions are being made the evening before, and I'm sending them out. That's a contact between myself and Mr. Sultan. If that somehow somebody is putting out the summaries of proposed, I don't know anything about that. That's the first I've heard that. But there clearly isn't anything. I know there's a suggestion made. Somehow, if we're trying to play to the media, that's not the case. And I think Your Honor knows that this case has been moving on. There's been no such suggestion of that. And so none of this motion deals in anything other than they've raised it in the opening, they've propounded that, and then now through the course of witnesses, we think as a matter of fairness, we can respond. And just the same way, if they're suggesting with a firearm. He didn't have a firearm. This is a cell phone or an iPad or an iPhone, which again was in the opening, and they continued to go down that way, we would then respond by suggesting there's a photograph of the defendant with a firearm, a Glock, which we had evidence that we'd offer, to rebut the suggestion that he doesn't have a firearm. So if they want to, again, offensively use prior court rulings and then to tie our hands.
You were just going to respond to the two issues on
Yes, Your Honor, those were my main points.
Thank you.
Thank you.
Motions in limine are necessarily based on what at the time the motions are heard, the court and the parties expect the evidence to be. If a defendant does open the door and makes evidence relevant that was previously thought not relevant or changes the weighing of prejudicial versus probative value, the court is free to revisit the issue as the defendant acknowledges. Accordingly, I have reconsidered the ruling, and after doing so, decide not to alter the court's ruling. The defendant has done nothing to date that reasonably can be viewed as opening the door to allow the evidence. The cases relied on by the Commonwealth do not support the proposition that the Commonwealth is now entitled to admit the prior bad act, or that it would be an abuse of discretion for the court not to permit the Commonwealth to introduce this evidence. For example, in the McGraw case cited by the Commonwealth, evidence that the defendant accused of murdering his wife previously had threatened the same person, namely his wife, by leaving a rifle on her bed was admissible to show the defendant's ill will toward the victim and to rebut the defendant's claim that their separation was amicable and that they were happy. The court made a point of saying that evidence of such prior misconduct is not admissible to show either bad character or propensity to engage in such conduct. Similarly, in the Oliveira case, the defendant's prior conviction of assault and battery on his ex-wife was found not to have been improperly admitted in a trial for assault and battery on the ex-wife in order to rebut the defendant's description of himself in his testimony as a peaceful, non-combative person who wished to avoid conflict. The court concluded it was not an abuse of discretion for the trial judge to rule that the defendant's testimony opened the door to the prior bad act evidence. But even in that situation, which is different from the situation here, the court characterized the question as to whether the defendant's testimony opened the door to this line of cross-examination as a close one, which the court stated that it may have, that the appeals court may have answered it differently if it were before the court in the first instance. Here, in contrast, the Commonwealth is seeking to use an incident of hostility toward one friend as evidence of the identity of the defendant as the one who harmed a different friend. The defendant's argument about lack of motive is not the legal equivalent of testimony that one has never used a gun or has never engaged in an act of violence, which may, in the court's discretion, be impeached with a prior bad act. In effect, the Commonwealth is seeking to use the Florida incident, which is quite different in terms of there being a clear motive, given the fight between the friends in Florida, followed shortly thereafter by Bradley making disparaging remarks about Mr. Hernandez in his presence and in front of others, and which is also quite different in terms of timing, as the alleged incident in Florida occurred very shortly after the provocation. The Commonwealth is, in effect, seeking to use that incident, which, as the court has noted again, is quite different, to show a propensity by the defendant to shoot his friends. At the time of the hearing on the motion in limine, the Commonwealth fully anticipated the exact matter that it today argues constitutes opening the door, and the court fully considered the Commonwealth's arguments at that time and found them to be unpersuasive. For example, at the last hearing, the Commonwealth argued that Bradley and Mr. Hernandez were friends and that there was no motivation, and that that's exactly the same as with Odin Lloyd, In fact, after the shooting, the defendant's saying he's like family. He's professing the same thing with Bradley here. I've got this good relationship with him. I have no reason to kill him or to try to kill him, just like Odin Lloyd. The Commonwealth anticipated that Odin Lloyd would suggest he's family, the two of them are dating sisters, and the Commonwealth anticipated that Mr. Hernandez would argue there was no reason to kill his friend Odin Lloyd. The Commonwealth argued that given the similarities in their relationship, both friends, the prior shooting should be admitted on the basis that it goes to the identification of Mr. Hernandez as the shooter. In its prior memorandum, in support of its motion to admit the Florida incident, the Commonwealth again anticipated what it now says is opening the door. The Commonwealth argued that the prior bad act was admissible to show identity, intent, or motive, and to rebut the defendant's contentions that it then anticipated would be made in the course of the trial. The Commonwealth argued that the Florida incident was admissible to show the defendant's distinct modus operandi, mainly that he eliminated individuals who, despite indicia of friendship, had fallen out of favor. The Commonwealth anticipated then that a key issue in the trial would be the defendant's role in the killing of Mr. Lloyd, and that to the extent that the defense can place principal blame for the shooting on one of the co-defendants, the defendant's prospects for a positive outcome would be significantly buoyed. The court explained at some length on the record the rationale for its ruling denying admissibility of the prior bad act, and I will not repeat the rationale here. The defendant seeking through questions to elicit evidence as to the nature of the relationship between Mr. Hernandez and Mr. Lloyd, or arguing that Mr. Hernandez had no motive to kill, as was fully anticipated when the court ruled, does not open the door. The court is of the view that its ruling on the motion in limine was correct when made, and that as of today, it remains correct. Of course, the defendant may still open the door. If, for example, he testifies he's never fired a gun, or that the Commonwealth may seek permission to impeach him with a prior bad act. That is not meant to be the exclusive or exhaustive way in which the defendant may open the door. But I do not find he has done so at this point, and the renewed motion to admit the evidence is denied. As far as the filing, I have not done a line-by-line comparison to the statements in the Commonwealth's brief to try to compare them against a transcript of the hearing. The hearing on the motions in limine was in public court. The fact that it involved a shooting and the circumstances of the shooting were discussed. The court in the defense distinguished the matters. The court in its detailed ruling went through many of the aspects to the extent the Commonwealth is reciting things that were in open court and not purporting, as was true in all of the papers that I'm aware of that have been sealed pursuant to the statute, where either the Commonwealth or the defendant has been actually citing and referring to grand jury transcript. It was not improper. As far as witnesses being mentioned in articles before they've appeared, I just simply will take the opportunity to remind both sides, without trying to ascertain who may have been leaking the information, of the existence of the order dealing with what may be said or not said to the media. Clearly, the court is not being made aware on a daily basis, so nothing's being filed in court. There's no public filing as to who the witnesses are the next day. And to the extent things are being, I would just ask everyone to remind everyone that you are dealing with, and your team, however that is defined. But I would just ask that both sets of attorneys remind their staff and the persons working with them, whether they be direct employees or not, that the order previously entered remains in effect and should be followed. Thank you. Is 10 minutes enough, or do you want 15? We'll resume then in 15 minutes. Thank you.
Folks, don't stand in recess.